Court today is the case entitled City of Burlington versus Sisters and Brothers Investment Group LLP, case number 24 AP 026. Representing the appellant, Sisters and Brothers Investment Group LLP, is Brian Hare. Representing the appellee, City of Burlington, is Kimberly Sturdivant.
Thanks very much, and good morning again. We'll hear from counsel for the appellant. First, of course, please introduce yourself and your client and then proceed.
May it please the court, your honors. Excuse me, my name is Brian Hare. I represent the appellant in this case, Sisters and Brothers Investment Group. Oh, excuse me?
No, I just said thank you.
Okay.
Thanks.
Yep. Your honors, this case is obviously made its second stop back to the Supreme Court. The reason it's back here, of course, is because of the remand order issued by this court, excuse me, which required the environmental court to recalculate the significant penalty amount because a significant piece of evidence was actually not in evidence, the 2004 agreement. Now, below, the environmental court stated that this 2004 agreement was particularly distressing, and it weighed heavily in favor of the imposition of significant fines upon Sisters and Brothers.
Mr. Hare, I'm going to excuse you for interrupting you, but aren't you essentially asking this court to direct the environmental division to reduce the penalty, which was not the order of this court on remand? The order of this court on remand was to recalculate the penalty without consideration of the aggravating factor of the 2004 agreement, which the environmental court judge did do on remand.
I agree with most of that, Your Honor. My point being that below, the environmental court judge placed great weight on the 2004 agreement, and then its alleged recalculating, you would have expected the penalty amount to have been reduced if the 2004 agreement was no longer part of the case, and that wasn't done. The exact same penalty amount was issued by the environmental court. And to follow that, Your Honors, that being the case, the exact same penalty amount having been issued, it suggests that the penalty amount is punitive, intended to punish Sisters and Brothers, since it did not perform the required recalculation. And I think it's only logical to assume that the recalculation would have resulted in a reduced fine because the 2004 agreement was ordered to be removed from the equation.
Or does it need to be compensatory as a penalty, or is it meant to be a punishment for non-compliance?
The environmental court's decision on remand, Your Honor, not changing or reducing the penalty amount, it appears to be punitive. It appears to be established to punish Sisters and Brothers. That's all I have, unless there's further questions, Your Honor.
All right. I don't see any hands, so we'll turn to counsel for the appellee. Please introduce yourself and your client and then proceed.
Good morning, Your Honors. May it please the court, my name is Kimberly Sturdivant, and I represent the City of Burlington in this matter.
Thank you.
This matter pertains to the calculation of fines for a zoning violation for an illegal parking lot at 281 Pearl Street in Burlington, which had a notice of violation issued for it back in April of 2019. It's established by the court that the violation occurred for 892 days. The environmental court initially held that the amount due to the city for the violation was $66,759.92, part of that being reimbursement for the city. The decision was remanded after appeal to this court with the request for the environmental division to recalculate the fines without factoring in the 2004 agreement. The Environmental Division recalculated the fine without consideration of the 2004 agreement and still found the $66,759.92 was still the appropriate amount. The Environmental Court Division followed the instructions on remand. He did not err in finding the same amount in fines. The Environmental Division appropriately looked at the economic benefit gained by its Sisters and Brothers violation, the city's enforcement costs, and the Uniform Environmental Law Enforcement Act factors, all without any consideration of the 2004 agreement or alleged knowledge of it. Based upon the Environmental Division's review of the criteria without consideration of the 2004 agreement, the court found the 50 per day fine plus reimbursement of the city costs to be appropriate. $50 per day is only a quarter of the maximum penalty of up to $200 per day and is appropriate, especially consider Sisters and Brothers' continued use of the property and receiving income from the illegal use after having knowledge of the issue for such a long time. At one point, the city counted 24 cars at the parking lot, at 24 cars per month at $150 per month, for 30 months. The income alone was would be $90,000. The lower court has broad discretion in setting fines for violation of municipal bylaws. The Environmental Division was within his discretion in setting the fine and reimbursement in this matter. While the 2004 agreement added additional reasons for a fine, it was not necessary and not used by the court to recalculate on remand. It was just added for support, but not needed given the rest of the evidence. And a party who alleges an abuse of discretion has the difficult burden of demonstrating that abuse. Sisters and Brothers have not demonstrated any abuse, and the judgment should be affirmed. Thank you.
Okay, thank you. How much time does the appellant have, please?
Appellant has 1 minute and 36 seconds remaining.
Counsel?
Thank you, Your Honor. I submit to the court that the Environmental Division's order on remand did not recalculate the penalty as it was requested to do. It simply acknowledged this court's requirement that it not consider the 2004 agreement. It didn't attribute any monetary value to that agreement in its decision on remand, but yet below, the court referenced it as the basis for the imposition of significant fines. So I think the failure to reduce the fine as ordered by the court is clearly erroneous. And I would suggest that it's punitive and that I would ask this court to vacate the penalty in its entirety as a result.
Okay. All right. Thank you both.